Oh, great. Welcome, everyone. Welcome to today's masterclass. We're going to get started in a minute. We are wrapping up this year's series. We'll talk a little bit more about that at the end. But I just wanted to say what a pleasure it is to present to this audience and how much we've enjoyed it. So we can go ahead and get started with the slides. Just quickly, I wanted to tell you a little bit about, we have our Vision AI practice, and we help businesses implement AI responsibly by providing integrated legal, compliance, and ethical guidance. And then we also have our wonderful Vision AI consulting group, and they help you by providing you with deployable tools, proven methods, and hands-on implementation. So your leaders can be armed and your companies can be both compliant and future-proof and bring AI to the market responsibly. So I'm Susan Duarte. A little bit about me. I spent about 20 years in-house before joining Marashlian and Donahue, the Con Law Group. I provide guidance on technology, advertising, data privacy, and consumer protection, and of course, AI. I love helping companies launch cool and innovative products and services, but I also like ensuring they navigate complex regulatory landscapes. And don't we have one for you today? I am really passionate about AI and the incredible opportunities it brings, and I'm really excited to talk to you today about this act. And I'm going to hand it over to my colleague, Brian. Oh, Brian, I think you're on mute, and everyone wants to hear
Oh,
about
it would
you.
help if I took the mute off.
Yeah.
Thanks for joining us, everyone,
Yeah.
and thanks, Susan. I'm Brian Alexander of Counsel with Marashlian and Donahue. I advise companies on AI, security, and privacy related legal issues, and work with companies to help them develop and use AI in a responsible and compliant way. In 2019, when Europe was deciding how to regulate AI, I had just started working for a European AI company. And some of my colleagues were deeply involved in government discussions about the AI Act. And as a company, we were helping organizations develop and deploy responsible AI in anticipation of this new law. So I've really followed this act since its inception, and I'm excited to discuss it with you today. As Susan mentioned, the EU AI Act is or alluded to, a big subject that could be covered in multiple courses. You can go to the next slide, please. But our plan is to give you the information you need really to understand the EU AI Act and how it may apply to you, and also what steps your company should be taking. So with that, let's dive in. I'm going to talk briefly about the history of the Act. Still on the agenda, sorry about that. I'll talk briefly about the history of the Act and what is in force and what's to come. Then I'll talk about the Act's scope, roles, and system classification. And Susan will help you understand the compliance obligations, especially for high-risk AI systems and general purpose AI. And she'll also talk to you about the EU AI Act and GDPR and how they interact. So we'll take some questions after that. Okay, next slide. Thanks. So why does it matter? If you are offering products in the EU market, or you have business operations there, then the EU AI Act will certainly be on your mind. If you are planning to do business in Europe, then your company should be considering the compliance requirements now. But for companies that don't think they need to consider the EU AI Act, I like to remind people about what happened with GDPR when that became law, because many companies, and some of which I worked with, were not really concerned with GDPR initially. Some were only marketing products in the US and thought that GDPR requirements like the right to be forgotten wouldn't impact their products. And then CCPA was enacted, then the CPRA ballot initiative passed, And that was followed by a proliferation of state privacy laws. And many companies had to reconsider their product offerings. And in some cases, that meant recoding projects to meet compliance requirements. And in other cases, companies who weren't thinking about going to the EU later changed their mind. They had to change the strategic direction. So, just asking you to consider how GDPR passed, and after that happened, the concepts from it were adopted in the states, and then the Colorado AI Act, which is in some ways analogous to the EU AI Act in that it regulates high risk AI, and it took cues from the EU AI Act too. Now the climate's much different now, but when it comes to those AI acts when they were passed, but we'll see these same concepts start to appear in state laws, and similar to what happened with the privacy laws. So let's talk briefly about the history. At the end of 2019, one of the main issues at the European Commission was how to regulate AI, and the Commission started 2020 with the intent to prioritize passage of an AI law that would continue the EU's really human-centric approach to technology. And many in Europe had issues with big tech, big US tech companies, AI companies using data of EU residents. Of course, at that time, also there were large breaches of personal data that were regularly in the headlines. But early 2020, COVID happened, which significantly delayed the work planned on the act. And then finally in 2021, November 2021, a draft of the act was published. And 2022 had a lot of heated negotiations, a lot focused on trying to balance individual protections against the need for EU companies to be able to really be fully engaged in the market and also to develop AI tech. And also general purpose AI came into the fold as well. We'll talk more about that. So there was a recognition that some of these systems could be used for different purposes. And then you may remember that it was November 2022 when ChatGPT was publicly released, and then by 2023 January there was 100 million users worldwide. So May 2024, the European Council formally adopts the EU AI Act. So now let's talk about what's in force or effective. August of 2024 was when the EU AI Act officially came into force. And in the initial stage of the Act's implementation, there was the EU member states had to designate national competent authorities. So that includes a surveillance authority to monitor and enforce compliance for AI systems, and also a body that acts as the fundamental rights protection authority. That entity is responsible for ensuring that the rights, that the use of high-risk AI systems complies with the EU fundamental rights laws. Member states were also required to designate an authority that will oversee notified bodies. Those are the bodies that will conduct conformity assessments of high-risk AI systems, and we'll come back to that. February 2, 2025, prohibitions on the use of AI systems with unacceptable risk began. So these are already in force as of this year. And I'll take more in a moment to talk about prohibited uses, but one of the other requirements was AI literacy, and that's required of all AI providers and developers. Anyone who develops or places on the market or uses AI that's subject to the Act, providers and employers must ensure their staff has sufficient knowledge, understanding, and skills to use AI systems responsibly and to assess the risks. And there's the EU AI Act website has a list of some of the AI literacy programs that are approved, if that's something that you need. July 2nd of this year saw the EU AI office release a code of practice that provides a framework for developers of general purpose AI, and they can use that to meet the EU AI Act requirements or to show compliance, really. August 2nd, a couple months ago or a few months ago, that code took effect, and it's voluntary but like I said, it demonstrates that a GPA model provider is complying. August 2nd of this year also saw provisions of the EU AI come into force that included the requirements for notified bodies, EPAI models, that's general purpose AI models, governance, confidentiality, and penalties. And next year, August 2nd of 2026, the remaining provisions of the Act will come into force with the exception of Article 6.1. And that one, Article 6.1 goes into effect August 2nd of 2027. It is related to specifically AI use as a safety component. So specifically, if there's an AI system that fulfills a safety function or the product or for a product or for another AI system. So, okay, next slide, please. All right, so for US companies, of course, it's important to start with an understanding of the scope. Does the Act apply to your current or planned offerings and business activities, or offerings and business activities if you're working in the EU? You can see on the slide here, and I'll come back to some of the roles in a moment, but providers are essentially AI developers and AI deployers are buyers, users. So the EU AI Act uses developers and deployers, but the Act applies to providers selling into the EU market, and importers and distributors also have obligations, being intermediaries, providers and deployers who are outside the EU, but that use AI outputs within the EU are subject to the Act. So a US company that's using an AI tool to evaluate CVs for a position that it's offering in the EU would be subject to the Act. Deployers that are located in the EU are covered. So companies that are buying using AI, they are covered. And any non-EU company that is offering AI products and services targeted at EU users, they're also subject to the Act. Now, there are some exceptions, systems used for scientific research and development purposes. Also, personal use of AI is excluded. The focus here is on providers and developers, although they can be individuals, providers and developers. Free and open source AI may also be excluded. Okay, so now let's talk a little bit about the roles defined under the EU AI Act. Providers are the companies that develop AI systems and place them on the market. Nope, still on the last slide. Still on, yep, this one, thank you. And most of the obligations are on the providers. Deployers are the buyers and users of the AI systems, but note that providers are also using AI for their own business purposes. So companies can be a provider and also a deployer for a particular system, and it really depends on the system. It's a system by system analysis, really. Distributors and importers that make AI systems available in the EU market also have obligations. Product manufacturers are companies that embed AI in products that they offer in the EU market. And then finally, authorized representatives are EU-based representatives or providers of high-risk systems that are located outside the EU. So in other words, if you're a US company and you're offering high-risk AI systems in the EU, then you must have an authorized representative that's located there. And Susan will talk a little more about GDPR and EU AI Act and how they interact together. But I wanted to note that the EU has a comprehensive regulatory regime covering technology. And many of the EU regulations have overlapping applications. For example, there's some on the screen there. The Digital Services Act regulates intermediary services and platforms on the internet. And companies providing these services are all using AI, and AI systems, of course, are regulated by the EU AI Act. The product safety regulations, which Susan will also talk a little bit more about, I think, is the EU AI Act was built to be complementary to these. So, and I'll talk more about this as well in the classification section. But the Act provides technology-specific requirements where the product safety regulations cover medical devices, machinery, toy safety, those kinds of things. And also there's coordinated market surveillance authorities, coordination of enforcement between the market surveillance authorities in these areas. And then finally, I was going to mention the EU Cyber Resilience Act, which covers cybersecurity of digital elements of products. And this includes AI systems, which are subject to those same security requirements as other digital elements are. Okay. You can go to the next slide. Thanks. All right, so let's talk about risk classification. The EU AI Act has a risk-based classification system, and it categorizes AI systems into 4 different risk levels. There's unacceptable, high, limited, and minimal or no risk. And at the same time, the Act overlays requirements related to general purpose AI systems, which include LLMs and other generative AI systems. These are systems, there's the systems that are posing unacceptable levels of risk, and those are prohibited. Talk more about those in a moment. And the majority of requirements are applicable to AI systems in the Act that they apply to really high-risk AI systems. That's where most obligations fall. So classification of whether a system is high risk or is not is really important. And it's the AI system provider that has the primary responsibility for determining the risk level of a system. Now I'm going to talk a little bit about limited and minimal risk systems first. Then I'll turn it back and talk more about the other categories. The Act addresses limited risk AI systems, which are subject to lighter transparency obligations. And these are systems that are really intended to interact with humans where the person is informed that they are not interacting with a human. But we'll come back to this. The technology is changing in this area, so that's changing a lot of how I think some of these things will be interpreted. Because some of the examples you see in the EU AI Act came from 2021, and things were quite different there in terms of the technology and how it was being used. An example is an interactive chatbot that's not otherwise high risk. Another example is generative AI systems that create synthetic audio, images, video, or text. So, now we're at a line here. You can see there's a lot of deep fakes coming out now. My kids show them to me all the time. The outputs must be labeled as AI generated or manipulated. Also, emotion recognition and biometric characterization systems that are not otherwise high risk. They can be limited risk if they comply with GDPR and they have the appropriate safeguards. And there are some other categories that I won't go into. Minimal risk AI systems are regulated according to the EU, are unregulated. And according to the EU, these are the majority of AI applications currently available in the EU market. Some examples they provide are AI-enabled video games, spam filters. Of course, we know that video games, there's a lot more now to some of the AI-enabled video games than there was back in 2021 in terms of what they do. But for both minimal and limited risk systems, the changes, as I mentioned, changes in the technology and uses are going to impact these risk categorizations. And I mentioned chatbots. At the time the EU AI Act was drafted, chatbots were, I guess, relatively speaking, more simple and narrowly focused in a lot of cases. And now you have LLMs integrated into a lot of these bots, and the uses have expanded. So My point here is to always consider the use and all of the system components, including the data. You can't just, draw a circle around the system so narrowly that it excludes all of the other things that go along with it. An example, yeah, I mentioned the chatbot example. So let me talk now a little bit about prohibited AI systems. Some of the prohibited systems included in the AI Act include systems that deploy subliminal, manipulative, or deceptive techniques. And you'll hear this or see this quite a bit to distort behavior, to impair informed decision making, causing significant harm. And I'll come back and talk more about significant harm in a moment. Other systems that are in the prohibited class are systems that exploit vulnerabilities related to age, disability, or socioeconomic circumstances, biometric categorization systems that infer sensitive attributes. And you have to remember that some of the sensitive personal information in Europe is different. They have also political opinions, trade union membership, uh, philosophical beliefs as well, some differences. There are some exceptions for biometric systems if for things like labeling and filtering, and that's if it's a lawfully acquired data set. And then there's also, in certain cases, law enforcement uses that are acceptable. Social scoring systems that evaluate or classify individuals based on social behavior or their personal traits. Assessing the risk of an individual committing a criminal offense, compiling facial recognition databases using scrapers on the web or CCTV, inferring emotions in the workplace or educational institutions, except for there's some exceptions to that, and real-time biometric, remote biometric identification in public spaces. So let's talk about high-risk AI systems, and this is obviously a really important category to look at. And providers of high-risk AI systems are subject to additional requirements, which Susan will talk more about. As far as the classification rules, they are in Article 6 of the EU AI Act. And again, it's primarily the AI system providers that are responsible for classifying the AI systems they develop and place in the market. AI systems can be classified as high risk in two ways. They're either high risk if they're used as a safety component or as a product covered by EU laws in Annex 1. And Annex 1 has a list of the harmonized EU product regulations. And if the product is required to undergo a third-party conformity assessment under product regulations. So that's one group. And then alternatively, a system is high risk if it's listed in Annex 3, and Annex 3 has a list of use cases. So, and if it's also not subject to an exception. So Annex 3 is what they use in the Act to list what are considered to be high risk AI systems. And they're always considered high risk if they profile individuals. So if they use automated processing of personal data to assess things about a person's life, their work performance, their economic situation, their location, and other things as well. Some of the high-risk use cases that are included in Annex 3 include remote biometric identification and emotion systems, AI systems that are safety components in critical infrastructure. So that includes digital infrastructure, as well as utilities, transportation, systems used to determine access to educational resources or to assess students, AI used to evaluate or hire candidates for the monitoring of worker performance and behaviors, AI used to determine essential services, which can be government and in some cases private services in Europe are considered essential services. AI systems used in emergency services and healthcare settings, and others related to law enforcement, border control, judicial processes, those kinds of things. So as you can see, if you're familiar with the Colorado AI Act, also there's some parallels there in terms of what is high risk under the Colorado AI Act, how that's defined, and the EU AI Act. There are some exceptions. I mentioned significant harm previously, and the act's aimed in large part at protecting fundamental rights. So there's an exception to the high risk class where a provider can make a documented finding that while their system is listed in Annex A, or excuse me, Annex 3, it is not high risk because it does not pose a significant risk of harm to people's health, safety, or fundamental rights. And providers that are offering AI systems that fall under Annex 3 but believe their system is not high risk, they must document that, their risk assessment and how they came to that before they place any of their systems on the market. Let me look at the time here. A few examples, I'll skip through some of these. Narrow procedural task transforming data for further human review, improving the result of a previously completed human activity. So like improving a draft of a document, that kind of thing. Pattern recognition to identify anomalies. In a lot of cases, these are predicated on there's a human involved. So an AI system that's expected to perform a preparatory task. And if you can think maybe of like a medical intake screening tool that then the doctor uses, but it's a minor part. The doctor uses that as an initial look, and then they're using other information that they gather to actually make decisions. Annex 3 is intended to be flexible. There's the list of high-risk systems is going to be revisited in February of next year. The EU will release guidance on the practical implementation of the Act and also Annex 3. Finally, general purpose AI. I mentioned earlier that GPAI provisions were added to the EU AI Act, and GPAI provisions overlay with the risk-based categories for the other AI systems. So the Act really provides a shared and a tiered framework for looking at these different systems. A GPA model like ChatGPT, it has its own set of rules, but if the GPAI model is integrated into a product, then the risk classification of the product also is going to define the obligations of under the Act. And just to be clear, a GPAI model or general purpose AI model means an AI model that displays significant generality in it and is capable of competently performing a wide range of distinct tasks, regardless of the way the model is placed on the market. So generative AI falls into this category, but keep in mind that other AI systems can be general purpose systems. GPA models, of course, can be integrated into different downstream systems and applications. We're seeing this everywhere, of course, LLMs being embedded in other products, and maybe your company is already doing that or planning to. And similar to other risk classifications, there's exceptions for GPAI models. So if you're using it prior to release in the market for research and development, then it's not covered, it's accepted. And let me see, GPAI system is a system that's based on a GPAI model. It can serve a variety of purposes. It can be used directly or via an integration. So in other words, it can be its own high-risk AI system, or it can be integrated in another high-risk AI system. So with that, I will turn it over to Susan to continue.
Yeah, that's as clear as mud. I don't know if anyone else's head is
Thanks for the vote
spinning.
of thanks for the vote of
No,
confidence.
not you, just in general. You did great. But I'm just going to talk about just the compliance for high risk. As you can see, high risk systems face the most stringent requirements under the AI Act, and providers must satisfy many criteria. And just so you know, as we were mentioning earlier, this law is like 180 pages in PDF. So there's just a lot to go through, but the bulk of it does talk about high-risk systems. So if you are doing your analysis and you think, oh, I have a high-risk system, you're going to trigger these things. So sort of just walking through it at a high level, if you do have a high-risk system, you're going to need a risk management system. And you're going to want to make sure that it has continuous risk identification, analysis, and mitigation. And you're going to want to regularly review it. You're also going to want to make sure that you've integrated in human oversight. So human in the loop is really important, making sure that AI system includes mechanisms for humans to intervene and see what's happening. Another key thing is really just beyond sort of technical requirements is making sure you have good, high quality data sets. You want to make sure you're employing relevant and representative data sets. But you also want to make sure you're implementing quality management systems to look at your systems. So you can sort of think about this as AI governance, written policies, procedures, instructions. Um, and you need to make sure that you're keeping your documentation for 10 years. We recommend sometimes that you consider even keeping it longer, but 10 years is what's written in the law. Providers have to report serious incidents within 15 days of identifying any causal link to their system, and they need to cooperate with authorities. I know Brian talked about that earlier in cyber events. Another key thing is just to make sure you're looking at data bias and you're really working to prevent and mitigate biases. And you also want to make sure you have comprehensive technical documentation so everyone understands the system, its compliance. And as I mentioned, having good record keeping practices, including you want to make sure you have automatic logging and that you maintain the logs for that required retention period of 6 months or longer as specified in applicable law. And then just you want to make sure you're just being as robust about it and that everything in your system is accurate. And then I guess one of the questions is how do you demonstrate compliance? Companies that have these systems or organizations need to demonstrate that they're compliance with all of these different listed things on the first part of the slide. Some systems use internal control testing to do conformity assessments, which is assessing the compliance of a system. And others may actually engage a third party to look at the systems and give them certificates that it is in fact in compliance. And then you have to affix what's called CE marking. So it's a visual marking that shows compliance. Here in the United States, you may see FCC or other symbols for compliance. It's a similar idea. And it's usually in the documentation or if it's possible with the system. And then if there's an EU database available, you need to register your system. And then just compliance doesn't end for you when the product hits the market. Providers must implement post-market monitoring. So you have to ensure that there's continuous compliance. You need to collect and analyze performance data. You need to report incidents. And some of those incidents we've seen even here in the United States of things that are causing death or harm. And then just disruptions to critical infrastructure or breaches of fundamental rights. For those who are actually using these systems, so more of the deployers or the distributors, they have a more limited function or of requirements, but they're still important. They must use systems according to instructions. They have to maintain human oversight and keep logs and also report risks or serious incidents to their providers or authorities. And then importers or distributors also have to verify conformity before they place the system available into the market. So I do think of AI as a product, so that would make sense that you would want to make sure that the product is in compliance before you put it out into the market. So we can go ahead to the next slide. Ryan talked about what a general purpose AI model is. Just the obligations for compliance here, they're more limited, but you must maintain and draw up technical documentation of what the model was trained on, its evaluation. This is not optional, it's required. You also have to make that documentation and information available to your downstream providers so they can understand the model's capabilities and limitations. And they need to know what your model can and cannot do so they can use it responsibly. You also need to make sure you have a policy to comply with the EU's copyright law. So we've talked a lot about how the AI Act is in harmonization with a lot of the other EU AI EU laws, and they cross-reference one another. So this is another example. And it's a significant one because you need to ensure that all the content you use for training respects these reserved rights. And it's frowned upon to scrape without regard for copyright. And you also need to make sure that you have your obligations ready especially for those with systemic risk. Beginning in August of last year, that's when it came into place. So if you're behind, you need to make sure that you are in compliance. So I guess sort of just, it's something that is actively enforced now and something that you need to be aware of for compliance purposes. We can go to the next slide. So as I mentioned earlier, I think of AI systems as more of a product. And when you have a product, you make sure you have privacy built in. And so the AI Act works in harmony with the GDPR. The AI Act is not intended to replace the GDPR. And there's different layers of protection. So the GDPR protects your personal data, and the AI Act governs systems and risk management, like we talked about earlier. Both of them talk about automated decisions. GDPR talks about it more from a data protection angle, whereas the AI Act talks about it more from a risk perspective. We do see many overlapping principles. So transparency, explaining the types of personal data you have under the GDPR and the rights that can be exercised by the individual. And then also in combination with that is the AI Act explaining the operation and what's included in the AI Act and the training that you use. And I think the combination of the two really provides strong transparency requirements. Also, there's accountability, and I mentioned earlier data quality, and of course, for both human oversight. Some key differences, so where they diverge. I mentioned earlier that the GDPR is about individual rights and lawful processing of personal information. But the AI Act is system level safety and performance and risk controls. So practical integration of both of them would be to make sure you're doing joint impact assessments. So currently today you should be doing data protection impact assessments for your products, and you should also make sure that you're doing that in combination with the required AI risk assessments. You're also going to want to make sure that you are accounting for your governance and aligning that together. You're always going to want to make sure that your DPO and your AI governance teams, if they're distinct, are working together. And I know Brian talked about some real world examples, and another one is an AI recruitment tool. So here, if you're using that, you'll need to make sure you have a legal basis to use the information and that you're informing your candidates and giving them notices, and you're honoring data rights and respecting the DPIA. But also at the same time, as Brian talked about, you're going to want to make sure you have bias testing and human oversight. You're registering your systems, documenting, monitoring, but they all have to go together in time. So we can go to the next slide. So as we talked about at the start of the hour, this is really something that you should be starting to work on now. So GPA, the general purpose AI models already have regulations that apply. High risk is coming in August of 2026. So something to be thinking about now. You should be taking comprehensive inventory of your AI systems. You want to develop your compliance plans and risk mapping. You want to continue to monitor and educate your employees on AI Act requirements. And then just prepare for what you might do in the event of a regulatory request or audit. Another key thing is contracts. So the EU AI Act doesn't just regulate AI systems, it's also going to impact how you're writing your contracts. They're now going to be somewhat of a compliance tool that allocates the responsibility throughout the AI supply chain. And you're going to want to make sure that your high-risk systems specify the system's intended purposes and limitations, technical specifications and installation instructions, human oversight requirements, expected accuracy, and you definitely want to make sure that you have in the contract clear data access and audit rights, clear liability allocation, update and modify your procedures to go along with the contracts, and then make sure it's very clear the incident notification requirements. So this is kind of a new layer to consider along with your DPA. But just both parties retain compliance responsibilities. And then I don't think we can drive this home enough. It's just coordinating across all aspects of your organization. So your privacy teams, your security and your product teams, but just also anyone else who has a seat at the table to make sure that everyone's coordinating and not working in silos.
Yeah, and I want to second that on the this third bullet point, because I see this a lot where there's AI governance, but it might be done in isolation. And there are other processes, privacy, security, vendor risk that are outside, and not all that information is flowing in. And it's one of the things with these AI systems that's recognized that you need diverse expertise to be able to understand and assess them, and to make sure that all the risks are understood. So, we definitely urge you to track forthcoming guidance from the EU AI office and the national authorities. And they actually have a great website with a lot of resources and tools. We didn't talk about some of this, but there are many other aspects of the law, things like sandboxes that are being created in the different member states for companies to test things out. But the EU AI office, which is the overall body, is an important one to monitor, because they're going to keep you up to date on what's going on, and they have a lot of resources there. I think I also mentioned the AI literacy as well. They have approved sites or approved courses for that. Timeline for compliance readiness. And we mentioned this, a lot of the things are already in force now with the Act, but there is going to be a reassessment. And in February of next year, there will be a document issued that provides guidance on the EU AI Act and the implementation thus far, and also takes probably another good look at the Annex 3 use cases and reevaluates that in light of the technology and what's changed. So make sure you keep that in mind when you're assessing how this law may impact your company, that there will be changes. It's meant to be flexible, and the changing technology is really going to dictate ultimately what's high risk in their view and not. So I think with that wraps up our steps towards compliance. And Susan, do you want to kick off talking about this, and or do you want me
Yeah,
to?
so potentially may have one more class this year, but just stay tuned. But if you are interested in us conducting more classes or another series in 2026, we'd love to have a thumbs up or something just to know that you're out there. We're definitely planning to do something, and we'd love to hear from you and get any feedback from you on things that may be of interest.
Yeah, thanks. And as Susan mentioned, we are considering one other course before the end of the year, uh, and that depends on a guest, special guest. So we're working with them. We'll see. If not, then we'll bring that back probably next year. But I mean, I've had a really great time bringing you all this information. It's been a lot of
Yeah.
information in each one of these courses that we brought you. And I've spoken with quite a few of the people that have also been on these webinars and gotten a lot of great feedback. So I really do appreciate that, all of that.
Yeah, so I don't know if anyone has any questions. I know it looks like we have one in the chat already. I'm not sure if you've seen it, Brian.
Let me see.
It's what if any AI Act exposure may the operator of a marketplace for third-party applications have, where the agreement license is between the AI developer and the end customer, but which may integrate with one or more of the marketplace's operators' own products.
Well, you have a really, we're talking about a complex law to begin with, but you have a
Yeah,
really complex because it could bring in the Digital Services Act and some of those other acts as well. So, I mean, those kinds of things would be difficult to, let me see, to really analyze in any kind of detail, but I don't see that in here. Did I miss that one? Oh, here it is.
yeah.
Okay.
I mean, I think
Let me see.
one of the key points is sort of how involved is this operator. So, I mean, the deeper you integrate your products and services into this platform, and the more you're having control, the more regulators might view you as more of a provider than just a distributor. But of course, it just depends on that level. So I don't know what your thoughts are, Brian.
Right. No, I think that's a good analysis. I mean, you have to figure out where you stand in terms of the role, and also and that's why we went through the classifications. You've got to look at that particular system, and do that analysis. But certainly those are the kinds of complicated relationships between the different parties that
Yeah.
are going to require, some really thoughtful analysis. But, if you're in that position, then now is the time to do it. Don't wait until the authorities come to you and they have an issue or raise an issue with it.
Yep. I don't know if anyone else has any questions. Well, if you think of questions, this is a lot to digest. Yeah, our contact information is here. And as always, we'd love to hear from you. So thanks
Yeah,
everyone for joining.
absolutely. And feel free to reach out to me. Feel free, please, to reach out to Susan if you need any help with anything.